Welcome to the lecture on the legal and institutional barriers to access to justice. This lecture is part of the module on judicial process. Some of the key words in this lecture are equality, delay, formalization, procedures, indigence, legal awareness, legal education, power imbalances, and corruption. Providing citizens with access to justice is a duty of the state. Access to justice refers to the arrangements made by the state to ensure that the people can avail the benefits of law and the legal system to secure justice for themselves. Assessing the degree of access to justice enables us to understand the chasm that exists between theoretical provisions and their practical application. It enables us to identify the barriers to access to justice, both legal and extra-legal, and accordingly, it enables us to seek remedies. The object of this topic is to throw light on the various reasons and factors impeding the access to justice for majority of sections of the society in our country. Access to justice needs to be understood on the basis of two criteria. 1. Equality before law, and 2. Equality of access to justice. Equality before law refers to the substantive protection of law available to all, while equality of access to justice refers to the existence of sufficient procedures and mechanisms accessible not only to the rich and the powerful, but also to the deprived and the marginalized to approach the courts and get justice. While the Constitution of India does provide substantive equality, equality of access to justice to all does not exist in reality. There are several barriers, legal and institutional, as well as non-legal or extra-legal. Legal and institutional barriers refer to the faulty legal system, an insensitive enforcement mechanism, complicated procedural laws, costly and time-consuming litigations, inadequate judicial infrastructure, legal ignorance, the intimidating nature of the legal profession, a complex court hierarchy, among many other factors. Illiteracy, cultural inhibitions, poverty, social seclusion, bureaucratic and political corruption constitute some examples of the non-legal or extra-legal barriers. The present topic is primarily concerned with the legal and institutional barriers, with occasional reference to the non-legal barriers in order to give a holistic picture. All these barriers either have a direct or remote impact on the access to justice. We will begin with the legal and institutional barriers. And probably the most important barrier under this category is delay in justice delivery. Justice delayed is justice denied. Unfortunately, India's legal system is languishing due to chronic congestion at all levels of the judiciary. It takes several years before one's case can be heard, and even after a decision, there are multiple levels of appeal, due to which it takes much longer for the decision to attain finality and conclusiveness. The backlog of millions of cases at all levels points towards the shocking inadequacy of the legal system. This problem of inordinate delay itself is a great barrier to access to justice that can be attributed to several other causes like time-taking procedures, frequent adjournments, insufficient courts, unfilled vacancies in judicial officers' posts, and ever-increasing litigations, both genuine and non-meritorious. According to a recent estimate although 1.32 crore cases are disposed of every year in subordinate courts, there is an influx of about 1.42 crore new cases every year. There is a grave imbalance between the caseload of courts and the resources made available to them. Another barrier is the lack of sufficient judicial infrastructure and technology. Lack of sufficient judicial infrastructure is one of the many factors impinging the access to justice. The problem is more acute in the subordinate courts, which usually operate from cramped spaces with lack of sufficient personnel. The procedure for digitization of records has not been uniformly implemented, and the maintenance currently is extremely haphazard. This often results in loss of documents, mistakes in scheduling, and delay in enforcement of judgments. While the infrastructure is much better in the higher judiciary with digitization, it will not have a great impact unless the same trickles down to the subordinate judiciary as well. The next problem is understaffing. While the inflow of cases in the lower judiciary is ever increasing, there is no adequate increase in the number of judges to adjudicate the matters, which is a major cause of delay in the disposal of cases. It is recently estimated that the judge to population ratio in India is 10:1 million, which needs to be 5 times higher to effectively deal with the number of cases. Judges in the subordinate judiciary are overburdened with cases of several categories. Further, the frequent transfer of judges results in rehearing of cases by the new judge and compounds the existing delay. Another barrier to consider is the lack of updated judicial training. With the growing importance of specialized areas of law like human rights, intellectual property rights, and cyber crimes, just to name a few examples, judges often find themselves inadequate to deal with the matters and do not have sufficient time to acquire the necessary training to adjudicate them. Lack of necessary expertise renders delay in pronouncing decisions. Further, there is no procedure in place to allow for the accountability of judges in terms of their ability to decide cases in a neutral manner and be learned in the area of the law that they are dealing with. This in turn affects their competence to decide matters effectively, which in turn becomes more serious given that there is nothing in the law as regards the accountability of judges, apart from their impeachment. And impeachment procedures themselves are extremely difficult. Another barrier is procedural laws providing opportunities to profit from delay. One of the major legal barriers for a common man to access justice is long drawn procedural delays due to lack of a mandatory ceiling on adjournments at different stages of the litigation. Adjournments are continuously sought by lawyers as well as the clients on various grounds. Adjournments as a delaying tactic affects poor litigants more as they cannot appear in court often and cannot engage lawyers for a very long period. Very often, frivolous suits are filed not due to a genuine cause of the client or to a genuine case of the client, but to harass the other party. Lawyers are supposed to be the officers of the court. They are supposed to have, and they do have, an extended role in the court process due to the adversarial process followed in India. However, ironically, there is no effective provision in the law to hold them accountable for employing deliberate delaying tactics. Overlapping jurisdiction is another barrier to access to justice. The existence of multiple courts often gives rise to the problem of overlapping jurisdiction, where litigants are unsure about which court to approach. Often disputes before the court relate to the issue of jurisdiction, which itself takes a long time to resolve. after which the main dispute remains to be decided. Further, there is often no uniformity in legal procedures across different forums regarding rules of evidence, involvement of lawyers, and the availability of appeals. This results in lawyers and parties being unprepared and asking for adjournments. There are many problems in the law itself, and this is the next barrier that we will discuss. For economically and socially disadvantaged people, the fundamental needs are food, clothing, shelter, education, and health. The enforcement of many such basic survival rights are caught in the webs of the non-enforceable directive principles of state policy enshrined in the Constitution, and the law and policy divide. Courts selectively refrain from interfering in a matter before them which involve policy decisions of the government. This is in honor of the strict separation of powers between the three organs of government: the executive, legislature, and judiciary. When the basic entitlements of vast sections of society do not find avenues for redress within the formal legal system, laws are rendered irrelevant for such sections of society. Thus, the legal system does not accommodate the immediate concerns of people who are in desperate need of justice. This is the problem existing in the law itself. In this context, it is hardly surprising that Justice Murlidhar has remarked that the economically and socially disadvantaged perceive the entire legal system as irrelevant for their empowerment and survival. Since it operates to oppress them and disempower them, they have to devise ways to avoid it rather than engage with it and get lost in the procedural quagmire of the judicial system. Further, in cases where the government is involved, the opposite party is often disadvantaged as the procedural laws grant certain exemptions and privileges to the government as a party, and thus create an imbalance between the contesting parties. Although these privileges are granted to avoid unnecessary litigation, they are utilized, or rather misused and abused by the government to the disadvantage of the civilian party. In addition to this, substantive laws are often outdated and out of touch with current realities, resulting in injustice to concerned parties. It is hardly surprising that the government has now undertaken an exercise based on the recommendations of the Law Commission of India to weed out irrelevant and obsolete laws. Another barrier that must be mentioned is the formalization of law. Access to justice is also hampered if the procedural law is too complex and rigid, making it difficult for people to comply with the laws. The language of the law is complicated for ordinary people to comprehend. Laws are printed in English, and translations in the vernacular languages are seldom available. Even if the laws were in a language that people comprehend, the terms and legal jargon used is often beyond their understanding and tends to alienate them. Strict requirements of locus standi and principles of evidence often deter people from approaching the court. However, the judicial recognition of the principle of public interest litigation has played a crucial role in relaxing and liberalizing the locus standi requirement, thereby increasing accessibility to justice for those who encounter numerous socio-economic barriers to approach courts. Another barrier is the free legal aid, which is actually not all free. Free legal aid is no doubt a statutory boon to millions of people who belong to the weaker sections of society. This has been provided under the Legal Services Authority Act 1987, which came into operation in 1995. Under the Act, women and children, members of scheduled castes and scheduled tribes, differently abled people, and people whose income is below Rs 1 lakh are entitled to free legal aid in the form of free legal representation at the cost of the state. However, in spite of this provision, access to justice is still hindered because legal aid lawyers who are appointed by the court often do not take these matters very seriously as they are not paid a decent fee for legal aid cases. Indigent people, in fact, end up paying extra legal fees to the legal aid lawyers to pursue their case with commitment. Further, legal aid mainly covers court fees, but during a litigation, the litigant has to bear many other costs related to transportation, documentation, file retrieval, scheduling, and as some remark, the bribes paid to various categories of officials at different stages. To exacerbate the inadequacy of legal aid in India, pro bono litigation is at a nascent stage and has not been able to remove barriers to access for indigent people. Next comes the intimidating conduct of legal professionals. In most cases, lawyers are in a dominating position and are exploitative. Under the appearance-based payment mechanism, prolonging of cases ensures a source for continuous money making, and the mechanism incentivizes delaying tactics by lawyers. Lawyers tend to provide little or no information to their clients and keep them in the dark, as a result of which clients are seldom equipped to check the status of their case and monitor its progress. The amount of fees charged is mostly arbitrary and there is no uniform transparent procedure to determine the payable fees. Ill temper and professional high-handedness force clients to maintain a distance, except when it comes to making payments as and when demanded by their counsel. Especially in the subordinate courts, ill-trained lawyers suffer from apathy and self-interest, because of which the interest of justice for their clients is marginalized. Judges at the subordinate level are so overworked that they do not have sufficient time or power to control such dilatory tactics employed by lawyers. This also raises questions about the present-day legal education system in India, which needs to be reformed to impart good legal education with professional ethics and critical skills so that lawyers are trained to understand the importance of using their time more efficiently and to ensure that delaying tactics are minimized. Lack of legal awareness also acts as a barrier to access justice and actually majorly contributes to delays in the justice delivery system. Due to the major role played by lawyers before the courts, most clients are quite clueless about the law and their rights in that regard. Therefore, parties will often not be able to identify when their lawyers are deliberately employing dilatory tactics and delaying their cause. Due to legal illiteracy, paperwork is very time consuming and leaves clients perplexed. Illiteracy also hampers the confidence of lawyers and clients, which results in them being suspicious of the court process and reluctant to adopt any conciliatory methods. Lack of legal awareness leaves most people clueless about the law and their rights and hampers their confidence in the legal system itself. It makes them more vulnerable to power mongers. These are some of the important legal and institutional barriers to access to justice. We will now proceed to examine some other barriers for access to justice. Apart from the above-mentioned legal and institutional barriers to access to justice, there are other barriers preventing access to speedy and impartial justice. Though they are related to geographical, economic, social, and ethical factors, they do have a huge impact on the right to access justice. The first such barrier is geographical barriers to access constitutional courts. When a case involves violation of fundamental rights or other rights, the matter is supposed to be filed in the High Court or Supreme Court as the case may be. This is a serious geographical barrier to access justice, as most rural people cannot travel to the relevant High Court or to the Supreme Court and afford the related costs of litigation. As a result, important legal remedies, such as a habeas corpus petition, are beyond the reach of many people. Thus, the division of subject matter jurisdiction between the Supreme Court and the High Court, as well as the subordinate courts, needs to be revised, allowing for access to constitutional remedies at the subordinate level. This involves beefing up the present strength of subordinate courts and training judges at that level so that they are equipped to deal with constitutional matters. The second such extra-legal barrier is indigence, which acts as an economic barrier. Poverty is a great economic barrier which undermines the possibility of equality in society and equal access to justice. When the poor are excluded from the rule of law, their work and assets become insecure and unprotected. Due to the vulnerability they face, many institutional obstacles while seeking justice against exploitation and deprivation. Prohibitive costs of litigation, especially in the higher courts, keep justice beyond the reach of indigent people. Further, since the litigation process is extremely lengthy, indigenous parties are severely affected as they often work for daily wages and cannot keep missing work to attend court. Another critical extralegal barrier is power imbalances. The socio-economic disparities existing in society also have their impact on the access to justice. The party who is socially and economically more powerful tends to intimidate and coerce the weaker party to withdraw the matter from the court or forces him to settle matters on terms that are not favorable to him. Witness intimidation and tampering also occurs, which has a direct impact on the outcome of the case. These factors severely block access to justice. In cases where the government is involved, the opposite party is often disadvantaged as government lawyers are granted adjournments easily, thereby delaying proceedings. Disadvantaged litigants also have to face the issue of bias, especially in matters where the government is involved, as inexperienced judges may tend to decide the matter in favor of the government. Corruption is another very important barrier to access justice, and this operates as a barrier both at the institutional level and at the individual level. At an institutional level, corruption results in abuse of court procedure and denial of access to justice. At an individual level, it denies rule of law, encourages nepotism, and hinders impartial justice administration. Corruption makes justice a commodity to be bought and sold and not to be administered and secured. The rich and unscrupulous foster corruption at all levels to get things done according to their specifications. It is the poor and honest who bear the worst in the process, and therefore it is the marginalized populations of society who are yet again denied access to justice and who form the majority of our society and our country's population. All these factors culminate in the important barrier or factor of the mystification of the law. The law being seen as something which is unattainable, which is for the powerful and the rich, and not for the common man. The aforesaid factors, taken together, have contributed to the law, lawyers, and the judicial system acquiring a veil of mystery from the point of view of many sections of society. Lawyers are the means through which citizens access the judicial system. Yet the power assumed by lawyers has engendered a general distrust of lawyers and the legal system by the general public. This has extended to the judicial system, wherein courts are presumed to bear bias in favor of the rich and mighty, further deterring disadvantaged sections from accessing the judicial system. The intimidating structure of the law and the judicial system in terms of the language of the law, in terms of the power politics, the complicated procedures, and corrupting influences makes courts seem like foreign lands to majority of aggrieved persons or victims. As Justice Muralidhar said, the law, the legal system, and the courts become something which the common man chooses to stay away from, which the common man thinks he is better not having anything to do with, and figure out other ways of securing justice to himself. These problems have not escaped lawyers and judges, and efforts have been made to overcome barriers to access to justice. In order to overcome the existing legal and institutional barriers and other legal and extra legal barriers, the legal system in India has evolved itself over the years to adopt a number of measures. Many amendments in substantive and procedural laws have been brought in to plug loopholes which acted as obstructions to ensure the equal access to justice. Judicial activism has acknowledged the concepts of public interest litigation and social action litigation as powerful instruments to bolster access to justice for millions of marginalized citizens. In this context, mention must be made of the recently set up Social Justice Bench by the Supreme Court, a bench which is dedicated to hear public interest litigation cases, both pending cases as well as fresh cases. This has been welcomed as a major boost to secure basic entitlements and fundamental rights to vast sections of society. The rights to basic entitlements of life and livelihood have been brought within the fold of the enforceable fundamental rights thanks to the judicial activism of the Supreme Court, wherein rights such as the right to health, the right to be free from sexual harassment at workplaces, among many other rights, have been brought within the fold of Article 21 and Article 14 of the Constitution. Free legal aid has become a statutory right for the socially and economically disadvantaged sections of the community and has played a role in mitigating the economic barriers to access to justice. The alternate dispute resolution mechanisms, the establishment of various tribunals, and the conducting of Lok Adalats are to a great extent contributing to making access to justice a ground reality. The high courts of many states have set up mediation centers which have proven to be very successful. Model examples being the mediation center set up in Delhi and the recently set up mediation center in Bangalore, run by the Delhi High Court and the Karnataka High Court respectively. The right to information has proven to be an invaluable statutory tool in the struggle for access to justice. Propagation of informal legal education fosters the legal empowerment of the common man. Pro-poor legal and anti-poor economic agendas are needed to include the majority of population into the justice delivery system. It is urged by many quarters, by lawyers, academicians, that the government shall shift its focus from the minimum allocation of an annual outlay for the judiciary to a reasonable allocation required to remove the bottlenecks existing in judicial infrastructure. An overview of the various factors impinging the access to justice and the various developments that are taking place in the Indian legal system to remove these barriers makes it clear that the Indian legal system still has miles to go to achieve a barrier-free justice system that is available to all, irrespective of their social, economic, and educational standing. Reforms have been made, important efforts have been taken, but it is imperative that these continue, that new efforts are made, that new grounds are broken, because access to justice is a basic right that must be available and must be guaranteed to all sections of society, whether poor or whether rich, whether weak or powerful.